water. All right. Immigration, white supremacy, and plenary power. This, I think, is where it gets really interesting. So white supremacy has a long and sordid history in the federal immigration laws. The immigration statutes openly discriminated on the basis of race starting in the late 1800s with the Chinese exclusion laws. By 1917, federal law prohibited the entry of all people from the Asiatic barred zone. The immigration statute imposed racially based national origin restrictions until 1965. And from 1790 to 1952, excuse me, that confused me there for a second. And from 1790 to 1952, the very definition of U.S. citizenship for persons not born within the U.S. depended on racial criteria. Federal law prohibited black people from naturalizing until 1870 and barred most other non-whites from doing so until the 1940s. Okay, so we have some history here. Constitutional challenges to these racist laws largely failed. The Supreme Court upheld the Chinese exclusion laws in the late 1880s, stating that, quote, if the government of the United States, through its legislative department, considers the presence of foreigners of a different race in this country who will not assimilate with us to be dangerous to its peace and security, its determination is conclusive upon the judiciary, end quote. Under the plenary power doctrine announced in the Chinese exclusion cases, federal courts were to grant broad deference to the political branches to regulate immigration. The plenary power doctrine has subsequently operated, for the most part, to insulate federal immigration statutes from developments in constitutional law for over a century. Challenges to facially neutral immigration statutes with a disparate impact on racial minorities must overcome not only the plenary power doctrine's restrictive review, but also the inhospitable legal landscape for such claims under the Supreme Court's equal protection jurisprudence. Even as to citizens' equal protection challenges based on race to facially neutral statutes require a showing of discriminatory intent, which in practice is extremely difficult to demonstrate. So this gives you a little basis for understanding how the law works. So when people say, what don't you understand about illegal, for example, I've heard that many times, you have to take this stuff into account, because what is legal and what is right, or what most people would think is fair or reasonable, is not necessarily the same thing. And the way the law is interpreted can take something that on its face, just basically just words on paper, and you go, okay, that seems okay. But if you care to interpret it in a way that is not okay, you can do so according to this kind of document, the plenary power idea, the doctrine, I guess we would call it that. So, okay, let us go on. While the Supreme Court has not recently considered an immigration statute that explicitly discriminates on the basis of race, its decision in Trump versus Hawaii suggests that plenary power would likely dominate its analysis. In June 2018, the Supreme Court upheld the Trump administration's Muslim travel ban, excluding citizens of several predominantly Muslim countries, despite the president's repeated expression of animus towards Muslims. Applying a highly deferential standard of review to the plaintiff's Establishment Clause claim, the court asked only whether the travel ban was plausibly related to the government's declared objectives. That standard would appear to discount even compelling evidence of animus when the government can offer any alternative, facially legitimate explanation of a policy. Trump versus Hawaii concerned the entry of foreign nationals and a purported national security rationale, circumstances that do not apply in all immigration cases. Nonetheless, the court's full-throated invocation of deference and its citation to classic cases upholding discriminatory immigration policies does not bode well for equal protection claims. Next part, equal protection successes in the lower courts. Okay. Litigants challenging Trump administration immigration policies that are accompanied by statements of racial animus are turning to equal protection claims, despite the plenary power doctrine and the hostile legal standard for those claims. And in some cases they are winning, at least in the lower federal courts. Two examples are illustrative. After the Trump administration rescinded the DACA program, several litigants filed suit raising claims under the Administrative Procedure Act, or the APA, Equal Protection Clause, and Due Process Clause. While the APA claims alleging that the Trump administration's decision to rescind rested on a flawed premise that DACA is unlawful, formed the core of district court and court appeals decisions, those decisions also referenced and credited the equal protection claims. Plaintiffs allege that the administration's decision to rescind DACA violated the Equal Protection Clause because the decision was motivated by animus against Latinos, who comprised 93% of approved DACA recipients. Courts have referenced this claim in their decision and upheld it against the government's motions to dismiss it. More water. Immigrants have also challenged the Trump administration's TPS terminations on equal protection grounds. Since President Trump took office, his administration has terminated the TPS designations of El Salvador, Haiti, Nicaragua, and Sudan, among other countries. A class of non-citizens challenged these terminations on equal protection, APA, and due process grounds. The plaintiffs alleged that the decisions were motivated by racial and national origin animus, as demonstrated by President Trump's numerous racially discriminatory and anti-immigrant statements. They also alleged that the White House applied direct pressure on the Department of Homeland Security to end TPS designations based on racist animus. In a decision issued after Trump versus Hawaii, the district court granted a preliminary injunction holding that the challengers had demonstrated a likelihood of success on their APA claim, and that they were serious questions on the merits of the equal protection claim sufficient to support the preliminary injunction. The TPS and DACA litigation illustrate that even with another claim as the principal basis of a court's decision, the equal protection claim, and the racial statements recounted in the brief to make out that claim, inform how courts frame the case as a whole. Okay, now we're going to move into the broader value of equal protection claims. Given the plenary power doctrine and the Supreme Court's Trump versus Hawaii decision, it is unlikely that, if the court ends up considering the TPS or DACA equal protection claims, those claims will prevail. But there are still important reasons for litigants to raise equal protection challenges and to highlight the illegitimacy of white nationalism as a basis for immigration policy. First, as Hiroshi Motomura observed nearly 30 years ago, even when courts apply plenary power to avoid review of constitutional claims, those claims may result in statutory victories in the same cases. Phantom constitutional norms like equal protection, which exist in mainstream constitutional law, but which courts have not typically applied directly to immigration policies, affect courts' decision-making as to the other claims in a lawsuit. In some cases, courts apply phantom norms through interpreting statutes to avoid raising serious constitutional questions. But as Motomura observes, constitutional norms like equal protection affect consideration of a case even without explicit application of the avoidance doctrine. And there is reason to believe that operation of this theory is even more pronounced when it comes to agency action as compared to legislative mandate. Now we're starting to fall into legalese here a little bit. So I guess listen carefully and try to get the gist of it, because I can't really explain what agency action means. For example, I've heard the term before, but I'm not sure. So bear with me on this. So, okay, to continue. Even if the Supreme Court is unfavorable to both constitutional and statutory challenges to the administration's immigration policies, there is a second reason to pursue and publicize equal protection claims. Equal protection litigation can frame public dialogue and advance the claims of social movements and promote extrajudicial political change by highlighting the core equality principle at stake. The equal protection argument promotes the public message that, while people can reasonably disagree over the proper scale and form of immigration, white nationalism can never be a legitimate basis for immigration policy. Litigation can frame public understanding about the nature of a grievance and the definition of a cause, whereas other legal challenges to immigration measures are often inscrutable to the public, like APA claims that DHS insufficiently explained a rule change or failed to follow notice and comment procedures. The equal protection claim articulates an intuitive harm and allows the public to grasp the stakes of a dispute, especially at a time when litigation often dominates news coverage of immigration. Highlighting the equal protection claim can focus public attention on core values, who we are as a nation, rather than on legalistic defects in policy enactment. I think that's a really important paragraph there, and it bears a little editorial comment. In political situations and in politics generally, and in community organizing and in working on social justice movements, a lot of the time, the media, the news, a lot of people focus on winning and losing. We won this. We lost this. And those are important metrics in the sense that if you win something, you move ahead. You've made a step. If you lose something, you move back. You move a step back. But when you factor in information being spread and ideas being disseminated and framing being employed, those things are important. And they are tools towards future successes. So a lot of the time, for example, I'll take a local issue. There was a really strong effort to replace Representative Rodney Davis at this last election, which fell short by a very small amount. So you could say, oh, well, we lost. We have this Trumpian guy. He's sort of mysterious. He puts on this sort of smiley face and pretends to be kind of, centrist, but then he always votes very, very hard right. And so a lot of people really wanted to get him out, and they came very close to doing it. But they didn't quite do it. But in that process, more people were educated about this guy. It will be much more difficult for him in the future to fly under the radar and kind of walk around being all smiley and then go around and promoting these policies. More people are watching and paying attention to him because now someone has articulated what is they didn't like about him. So they've said, well, here's what's wrong with Rodney Davis. And so some people are like, well, I don't care, or I don't know. But now they're aware that this is supposedly, according to someone, what is wrong with this guy. And they can, from that, have a framework for judging his actions going forward. So over the next years or so, when they read something about him, they'll go, oh, I see. That sounds exactly like what those people were complaining about. And so all the people who didn't really know anything about him before or weren't really paying attention to him before are now aware of him and supposedly what is wrong with the way he governs. So it is very important when approaching these kinds of issues to think of the effect that the discussion itself, that the fight itself will have on people. Sometimes it's a negative thing. Sometimes fighting something, you can stand to gain a little bit, but you'll lose more in the metrics, or not the optics, not metrics, but optics of the fight itself, if you have to fight really dirty. Now, here's an example of how that works. So in political campaigns, you hear about candidates going negative. So they start out going, well, I'm going to run a positive campaign. And they talk about their vision for the future. And my worthy opponent says this, but I say that. And this is why my vision is more important. When the campaign starts to tighten and things get rough, they go negative. And suddenly it's, my opponent is, kills small puppies and chews on flowers for breakfast and is evil and terrible. They start trying to destroy their opponent. That can work, but it leaves a bad taste in everybody's mouth. And sometimes you can win that way, but you come out looking so bad, so mean, so like such an unpleasant person that you end up kind of destroying your own image. And then you have to operate with this new image of being someone who's just really nasty and petty. So these are ways in which the fight itself and how the fight is fought, if I can put it that way, become tools in and of themselves, even without necessarily winning your battle or your court case or whatever. So I think that part here was really important, and I wanted to expand on it a little bit. So let me get back to the story because I'm running out of time here. The equal protection narrative also supports communities that are suffering from racialized immigration enforcement by countering the exclusionary message of President Trump's policies. Unlike more technical arguments, equal protection claims speak to the indignity, dehumanization, and lack of belonging experienced by affected immigrants. Naming the grievance as white nationalism helps align legal advocates with the broader movements they support. The narrative may also propel advocates to de-emphasize other narratives that divide immigrant communities, like the prevalent cultural frame that dreamers are responsible, good immigrants in contrast to undeserving others. Centralizing the equality narrative may also help immigrants' rights advocates pursue political reform because of the capacity of legal frames, narratives, and performances to construct identities and meanings. Let me say that again. Centralizing the equality narrative, talking about equality as your main point, may also help immigrants' rights advocates pursue political reform because of the capacity of legal frames, narratives, and performances to construct identities and meanings. In other words, this is what people are always trying to do in political fights, is be the first one to frame an issue. Think of, for example, pro-life versus women's rights. You've got the two sides are trying to seek to frame theirs as a positive thing. I am pro-life, therefore I'm against abortion. I believe abortion is okay, therefore I am for women's right to choose. So each side is trying to frame something, and by letting somebody take on, I'm pro-life, mantle, they ignore, for example, the big complaint about many pro-life, quote unquote, people, is that they don't care about children once they're born. They only care about them when they're pre-born, as they say. And that once they're born, it's like, oh, well, you're on your own then. I don't care. So, it's that kind of image. It's like everybody's trying to frame things in a way that makes their cause sound right. And that's what that little bit right there was about. So back to the story. In fact, even a high-profile loss on the equal protection claim can help mobilize political reform, which is what I was talking about a minute ago. If advocates drive home the message that political leaders must resist white nationalist immigration policy because the courts have failed to do so. When plaintiffs centralize the equal protection claim, justices who dissent from decisions rejecting that claim are more likely to do so in terms that can galvanize a popular response. Lanny Guinier has argued that dissents can promote democracy when they, 1, engage with a significant issue of democratic legitimacy, 2, are written in an accessible public style, and 3, inspire non-judicial actors, including legislators and ordinary people, to act collectively to revisit the majority's conclusions. A dissenting opinion that amasses the evidence of discriminatory intent and declares white nationalism is a fundamentally impermissible basis for immigration policy, and declares white nationalism a fundamentally impermissible basis for immigration policy, has potential to mobilize democratic engagement and political reform. Third, asserting equal protection claims allows litigants to promote a constitutional framework in immigration law that a future Supreme Court may recognize. In that framework, contrary to the plenary power doctrine and Trump versus Hawaii, courts would not give special deference to the political branches when reviewing immigration policies. Immigration policies motivated by discriminatory animus would be deemed unconstitutional, and courts would strike down policies where significant evidence of animus exists, regardless of whether other reasons for the same policies could be hypothesized. That framework would bring immigration law within the larger fold of constitutional law, including the development of the idea of animus as an illegitimate basis for state action under the court's equal protection doctrine. Challenges to immigration policies that name the harm, white nationalism, and articulate a different vision of the law grounded in contemporary notions of equality may not succeed today, but they make clear what is at stake in a way that may instigate future constitutional law reform. Okay. Bar water. Excuse me. Conclusion. Finally, we get to the conclusion. Some may object that emphasizing race may alienate members of the public who would respond more sympathetically to universal or humanitarian narratives, or distract courts from narrower legal arguments with a greater likelihood of success. We recognize that a uniform approach may not be appropriate in every case, and that the communities affected by various measures and their lawyers have to assess potential costs against the benefits we have outlined. But in making that assessment, lawyers in particular should consider that clients, social movement actors, and even the general public may be well ahead of lawyers in recognizing the racism behind the Trump administration policies. Moreover, the failure to raise equality claims presents its own risk, normalizing white nationalism in our political and legal life. If legal actors cannot call out racism even when it manifests, hard word to say, if legal actors cannot call out racism even when it manifests in the express comments and policies of the president, there is little hope of countering it in its more subtle and pervasive forms. This was by Jayashri Srikantia, a professor of law and founding director of the Stanford Law School Immigrants' Rights Clinic. And this is was from the Stanford Law Review, and so I thought it would be useful. I have actually a whole other essay, which I'll get to next time, because it follows in the wake of this, and I'll give you the introduction of it right now so you can see what I'm talking about. This one is entitled Crimmigration Beyond the Headlines, the Board of Immigration Appeals' Quiet Expansion of the Meaning of Moral Turpitude. Actually, the introduction is really long, so I won't read it. But basically, I'll read part of it. The multiple entanglements of immigration and criminal law, known as crimmigration, include the reality that certain criminal convictions can lead to deportation, detention, and disqualification from immigration relief. Crimes involving moral turpitude comprise one of the many categories of crimes that can elicit adverse immigration consequences, affecting thousands of people each year. But the precise meaning of moral turpitude has long been elusive. Courts have stated that CIMTs, crimes involving moral turpitude, must involve an amorphously defined culpable mental state and reprehensible conduct, and looked to the Board of Immigration Appeals, a sub-agency of the Department of Justice that reviews immigration court decisions and is subject to some judicial review by the federal courts of appeal, to define the scope of moral turpitude. However, a series of BIA decisions over the last 2 years suggests that the board has expanded the definition of moral turpitude in ways that defy common sense and undermine the prevailing methodology for assessing the immigration consequences of crime. So I'll give you that teaser for next week. the point of this, obviously, is, again, we're talking about law, and we're talking about how law is, it's not just what a law states, it is how it is interpreted by judges, by the Supreme Court, by people who are, looking at the law from the outside and going, oh, isn't there a law about this? Everyone interprets the law in a way that they think makes their point. So the law is just like these, just bold statements of this is acceptable, this is not. You can do it under these circumstances, you can't do it under those, etc. But it's how you define what those circumstances are. For example, in the meaning of moral turpitude, which we're going to get to, or it's how people understand the law in terms of like cases that come up and how they're presented, and how they go, oh, I see. This is a case of right and wrong based around fairness, or this is a case of, knowing that there are legal fine points at issue is not very helpful, because those don't mean a lot to people most of the time. It's like, oh, you filed it 2 weeks late? Well, what difference does that make? Or you didn't assign the proper, you didn't format it properly. It's like turning in your student paper and they go, oh, well, this is not in the APA style or whatever, those kinds of things, those seem just, they make sense to the people that have them, but they don't make sense to other people. So they seem petty and picky and like you're just trying to find something wrong. And so when your court cases are based around those little fine details, a lot of the time, as I was saying earlier, you can win and still lose because people think you kind of cheated. It's like, oh, well, you couldn't win on your major point. You couldn't win on right and wrong or guilt and not guilt, but you won on a technicality. You've heard that before. It won on a technicality, was released on a technicality. The lawyers, of course, are trying to do that because they want to get any advantage that they can. But in the broader scheme of things, that doesn't resonate well with people, and it doesn't make people feel that justice is being done. So one way of looking at these things is you have to frame them in a way that explains how this is an issue of justice, right and wrong, fairness and unfairness, good and bad, if you want to look at it that way. So next time we'll talk about the moral turpitude thing, because I think that's an interesting point, and you can get into some of the more detail of how all it takes is someone to just take a vague concept and define it the way that makes things work out the way they want it to, and a huge shift can take place, and a huge shift has been taking place under this current administration. And it's something we really need to keep an eye on, because they're doing a lot of damage and a lot of people are getting hurt. And it's up to us, the people, to do something about it. We have to stop it. We have to elect people that are not going to do those things, who are going to fight back against those things. And it's an ongoing fight and an uphill battle at this point, but I think we will prevail. In any event, I've run out of time. You have been listening to CU Immigration here on WRFU-LP Urbana 104.5 or UPTV. We hope you'll tune in again the next time. And until then, we'll see you later. Bye-bye.